Welcome to INN Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Utkarsh Jadhao. He is going to speak on recognition of live-in relationships by Indian courts. He is from KES Shri Jayantilal H Patel College of Law. So without wasting further time, I would request him to commence with the lecture. Thank you.
Hello everyone, my name is Utkarsh Jadhao. Today I will be presenting my article on the topic of recognition of live-in relationships by Indian courts. This topic is very relevant in the modern world because live-in relationships are becoming very common and raise importance in legal and social importance. Through this topic, we will be able to understand how Indian courts are adapting the law to change the social realities of live-in relationships. My topic is divided into 5 parts: introduction, legal recognition by Indian courts of live-in relationships, rights in the live-in relationships, and the social and legal challenges faced by the partners who are living in live-in relationships, and the conclusion of the topic. So here, I begin with the introduction of the topic. A live-in relationship is generally said to living together without tying a knot. Here, a knot means without getting married. In India, living together before marriage was seen as a crime or offense as per the Indian culture for long time. If you talk about the previous times in Hindu Dharma, they preferred Ekapatni Vrat, which means one man who will have one wife, as one of the most holy forms of matrimony. But now people have started to evolve with time and started accepting new forms of relationships. The live-in relationship concept is not recognized as a legal union in India like some other countries. However, by the Supreme Court of India has said that a live-in relationship without tying knot is not a criminal offense or it is not an illegal offense. Partners living together without marriage do not have the same legal rights just like married couples, but they have legal protection under laws. In India, Hindu Marriage Act, Special Marriage Acts for Christians, Parsis, or either of the religions are the major laws which govern the different religions and their types of marriages. But there are no specific laws that are directly governed for live-in relationships. But here is the focus on the point that the court have recognized them through various types of judicial precedents and the decisions made by the justice to protect the rights of the partners, especially women's and the children's, because those are the very vulnerable sections of our society. Here I come to the end of my first topic, which was an introduction, a short introduction to the topic. The second brief I would like to give on legal recognition of this live-in relationship by our Indian courts. In Indian courts have gradually recognized live-in relationship as valid relationships under certain condition. The judiciary has held that living together without marriage is not an illegal or criminal offense. The Indian legal system do not explicitly define or regulate live-in relationships. However, over the years, various judgments by Indian courts have acknowledged the existence of relationship and granted certain rights of the partner. Now we will come to and case law, which defines that live-in relationship is not an illegal offense. Here is the case law of Supreme Court S. Khushbu versus Kannimal and others of 2010. S. Khushbu was well-known actress who gave an interview to a magazine where she expressed her opinion on premarital sex and live-in relationships were becoming common in society, and that society should accept that relationships. After this interview, several criminal complaints were filed against her in Tamil Nadu. The complaints were alleged that the statements of her made encouraged immorality, inserted Tamil culture, and promoted premarital sex. Cases were filed under various provisions of Indian Penal Code at that time against her, including defamation and obscenity of their culture. Issues raised in this case law was whether expressing opinion about live-in relationship and premarital sex amount to an criminal offense or an illegal offense, whether such relationships are illegal in India. Here the judgment of Supreme Court came that the Supreme Court of India quashed all the criminal complaints filed against S. Khushbu. The court held in 3 points that live-in relationships between consenting adults are not illegal. Merely expressing opinions about social issues cannot be treated as criminal offense. Morality cannot be imposed through criminal laws. These three were the points which were highlighted in that judgment in 2010 of these case laws. And most importantly, the principal evolved from this case law was Article 21, which states that no person shall be deprived of life and personal liberty except according to provisions of our established law. Over time, the Supreme Court has interpreted personal liberty in very broad angle, which includes right to privacy, right to dignity, right to choose a partner of our choice, and right to decide how to live our own personal life. So, if two adults voluntarily decide to live together, it becomes a personal decision which is protected under Article 21. A simple real life example, if we take, is suppose a man of 25 years old is living with 23 years old of a woman, decide to live together in a flat without getting married. 2 points here comes that both are adults and both have consented to live together in that relationship. In such situations, society may approve or disapprove, but law cannot punish them because it is not illegal, according to earlier case law. Their decision is considered as the part of the personal liberty under Article 21, which was the principle evolved in the last case law. Now, the second topic, we come to the legitimacy and the inheritance of the rights of the children in this. Tulsa and others versus Durgavati versus and others in 2008 judgment of Supreme Court of India, they clarified that the evidentiary presumptions of valid marriage arising from long time cohabitation, the case is frequently cited precedent in Indian family and property law, reinforcing the principle that law leans towards the legitimacy rather than the concubations. Rights in live-in relationships recognized by our Indian courts. This is the second topic which we come to. Indian courts have recognized certain rights for partners in live-in relationships to protect them, especially women's and the children's, because I earlier told that these two are the vulnerable sections of our society. In this topic, we will be talking about the rights of right to protection and protection from domestic violence, and right to maintenance, right of children born from live-in relationships, right to personal liberty and choice of our partner, and presumption of the marriage. If we come to the first point, right to protection from domestic violence, women in live-in relationships are protected under Protection of Women and Domestic Violence Act 2005. The act includes within its scope a relationship in the nature of a marriage. This means that if a woman is living with a man in a relationship similar to a marriage, she can seek protection under this law. The rights available to women include protection order, residence right, monetary relief, and the compensation order. Here, protection order means the court can restrain the partner from committing violence or harassment on the woman or the children. Residence right means the woman has the right to live in the shared household and cannot be forcibly removed from the household. Monetary relief means she may receive financial support for medical expenses or other losses caused by the abuse on the basis of her lifestyle. Compensation order means court may grant compensation for mental and physical injury. Here again a case law comes. The Supreme Court has clarified this in Indira Sharma versus VKV Sharma 2013 judgment, where it explained that women in genuine live-in relationships should not be left without legal protection. Here, genuine means the couple live together for a significant period of time. they should have shared a household. They present themselves to society as husband and wife. The relationship is stable and not just called as a casual relationship or a secret relationship. Now, the second right comes right to maintenance. Maintenance refer to the financial support provided to a partner without who cannot maintain themselves. In certain live-in relationships, court allow women to claim maintenance in the relationship resembles like a marriage. This was explained in D. Velusamy case of 2010. The court stated that live-in relationships will be treated as a relationship in nature of marriage when both partners are legally of the age of marriage. They live together voluntarily for a long period of time. They present themselves as husband and wife in a society, and they should share a same household, a common household. If the conditions are satisfied, if these four conditions are satisfied and the man abandons the woman, she may claim for the maintenance similar to that of wife. And this maintenance, an important point, that this maintenance can be taken for the children born from that live-in relationships. Rights of children, here the third point comes, rights of children from the live-in relationships. Children born from live-in relationships are not considered illegitimate under Indian law. In Tulsa versus Durghatiya 2008 judgment, the Supreme Court held that when a couple live together for a long time, it can be presumed that they are married and therefore the children born from such relationships are legitimate. The pronouncement here are the 4 lines of the judgment of the last case law, Tulsa versus Durghatiya of 2008. Here, Honorable Supreme Court ruled that children born from live-in relationship will not be illegitimate with an importance precondition that parents must have lived under one roof and cohabited for significantly long period of time for the society to recognize them as husband and wife. Rights the children get from those relationships, who are born from those relationships, are right to legitimacy, right to parental property, and right to maintenance and care. Right to legitimacy means they cannot be labeled as illegitimate by law. Right to parental property means they have inheritance rights in the property of their parents. Right to maintenance and care, which means parents are legally responsible for the child's upbringing and their maintenance according to their lifestyle. This principle protects children from social and legal discrimination happened upon them. Fourth right comes right to personal liberty and choice of partner. The court held that choosing a partner and deciding to live together are personal lifestyle choice, and such choice falls within the right to liberty and right to life under Article 21, as I mentioned in earlier case law S. Khushbu of 2008. So they cannot be criminalized by law. The Supreme Court interpreted that this right broadly in S. Khushbu versus Kannimal and others, stating that consenting adults have the freedom to choose their lifestyle. Living together without marriage is not a criminal offense. The state cannot interfere in the private relationships between two adults. Therefore, choosing to live with a partner without marriage is treated as personal decision protected by our Indian Constitution. The fifth right, presumption of the marriage, comes from the case law Badri Prasad versus Deputy Director of Consolidation 1978. Justice Krishna Iyer held that if a man and a woman live together for many years like husband and wife, the law will usually assume that they are married. These assumptions can be challenged, but the person who says the marriage is not valid must prove with a strong evidence. The court also said that it would be unfair to seek people to produce witness or proof of their marriage ceremony after many years, because such evidence may not exist anymore because the marriage has happened earlier time. Therefore, the law prefers to protect the relationship and ensure the social justice for the people who are getting married in those relationships. Fourth topic comes social and legal challenges of live-in relationships in India. Live-in relationships where a couple live together without formal marriage are gradually gaining recognition in Indian courts. Courts have acknowledged such relationship to protect individuals' liberty and right to partners and children. However, despite judicial recognition by the Supreme Court of India, several social and legal challenges still exist in India. Social stigma and cultural oppositions. Indian society traditionally views marriage as only acceptable form of a relationship between a man and a woman. Because of the cultural belief, couples in live-in relationships often face criticism and disapproval from their family members and also from the society where they live. Even though courts have held that live-in relationships are not legal, then also the social acceptance is still limited, especially in the conservative communities. Second point, lack of specific legislations. India currently does not have a comprehensive law or act that regulates the live-in relationships. Most legal protection has developed through court judgment and their precedents, and certain provisions of protection of women from Domestic Violence Act like 2005, which recognize a relationship in the nature of a marriage. Third point, difficulty in proving the relationship. In many legal disputes, it becomes difficult to prove that a live-in relationship actually existed. Courts usually consider such factor as the duration of the live-in relationship, whether the couple has shared a same household, whether they have presented themselves to the society as husband and wife. These conditions were discussed in D. Velusamy case, which I discussed earlier in the third topic of 2010. However, if there is no documentary evidence or witnesses proving the existence of such relationship can be challenging. The fourth point comes that the property and the inheritance issues which the wife and the children majorly faces. Another major legal challenge concerns property rights between partners. Unlike married couples, partners in a live-in relationship do not automatically have inheritance in each other's property. Problems may arise when one partner dies without leaving a will. There is a dispute regarding ownership of jointly used property such as a bank account, such as any movable or immovable property. And the third point is financial contribution during the relationship is unclear. Here the fifth point comes where the limited legal protection for the partners are arising. Although women in live-in relationships are protected under Domestic Violence Act of 2005, legal protection is still limited compared to the married couples because marriage is very much legal in our field. For example, there is no clear law regarding division of property after the separation of live-in relationships. Rights and responsibilities between the partners are not fully defined because we do not have any type of legislation. Protection for male partners or financial disputes is less clear in this type of relationship. Lack of awareness of legal rights. Many individuals are not aware that certain legal protections are available to partners in live-in relationships. For instance, women can seek protection and residence under the Protection of Women and from Domestic Violence Act 2005. Due to the lack of awareness, victims of abuse may not approach the courts. Partners may not know their legal remedies in this. Legal disputes may remain unsolved. Now I come to the conclusion of my topic. In conclusion, the recognition of live-in relationships by the Supreme Court of India and other courts reflects the changing social realities of modern Indian society. Although there is no specific legislation governing such type of relationships, courts have played an important and a major role in protecting the rights of women and both of the partners, particularly women and children. Though important judgments such as Indra Sharma versus VKV Sharma of 2013 and D. Velusamy of 2010 and K. Khushbu of 2010, the judiciary has clarified that certain live-in relationships can be considered as the relationship of the nature of marriage. These decisions ensure legal protection under law like Protection of Women from Domestic Violence Act 2005 and uphold the personal liberty from Article 21 of Indian Constitution. While social stigma and legal uncertainty still exist, judicial recognition of live-in relationships show that the law is gradually adapting and changing the social values and aiming to provide justice and protection in the contemporary society. This was all about my topic of live-in relationships recognition by our Indian courts. Thank you very much.
Utkarsh, thank you very much. It was a nice overview of the living relationship because this is a very topic which is now in tune, and I think the law is still to be evolved.
Yes.
Because even though a law may come, but then there will be amendments, case laws.
Yes.
So thank you. It was a nice hearing, a good research topic you had presented. A small token from Hammurabi to you.
Thank you very much.
Yeah.